Good afternoon and happy Data Protection Day, happy Privacy Day, everyone around the world. I'm Riccardo Masucci, Global Director of Privacy Policy at Intel. And today I have the honor to share this virtual stage with policymakers and experts from around the world. I would like to start introducing my panelists. We start with Mrs. Audry Plonk, Head of the Digital Economy Policy Division of the Directorate for Science, Technology and Innovation at the OECD. Good afternoon, Audrey. Thanks for joining. We have then Mrs. Samm, Cyber Policy Fellow at New America and Senior Fellow at the Yale Law School. Good morning, Samm, and thanks for joining. We have also here in the room Bruno Gencarelli, Mr. Bruno Gencarelli from the European Commission, Deputy Director of the Directorate for Fundamental Rights and Rule of Law, as well as Head of Unit of the International Data Flows Unit at DigiJustice. We will be joined also by Mrs. Meenakshi Lekhi in a few minutes. I'm very honored to have her on the panel. She's a member of the Indian Parliament and also the chairperson of the Joint Parliamentary Committee on the Personal Data Protection Bill that is now under discussion. So I'm envisaging a moderated discussion of roughly 50 minutes, and then I will open it up for Q&A for other 20-25 minutes. So I would invite the audience to write their questions so that we can then share them with the speakers later on. So let me start. Let me welcome Mrs. Meenakshi Lekhi, who just joined. Good evening, and thanks a lot for connecting such a late hour for you. Thank you for being here with us today.
Thank you.
So I suggest we start. We have a phenomenal panel of experts, so I really want to get us started. And if we look at data sovereignty as the ability to control data by both governments and by individuals, I feel that privacy and national security concerns really represent a major driver for data sovereignty, impacting both global data flows, but also the way we can deploy and develop technologies. This tension between privacy and national security was particularly evident and apparent, I feel, in the Schrems case, as well as in the Tik Tok case in the US. So for the first round of questions, I would suggest to start with Bruno and Samm to talk a bit about US and US-China. And then I would like to ask Mrs. Lekhi to tell us more about how the national security dimension influenced the debate on data localization in the Joint Parliamentary Committee that she chairs. And finally, I would like Audrey to tell us more about the current and the future work that the OECD is doing on data localization and law enforcement access. So with this, Bruno, over to you.
Yes. First, can you hear me well?
Loud and clear.
Very good. So thank you very much, Riccardo, for the invitation. Hello to my co-panelists. Well, that balancing between, indeed, that balancing between national security on the one hand and privacy on the other hand is very much at the core of the last July Schrems II judgment that invalidated the privacy shield. But this is an issue which is important beyond the borders of Europe. I think there is an increasing understanding and realization that you can no longer separate the completely separate the commercial sphere on the one hand and the law enforcement / national security sphere on the other hand. because of technological evolution, because often the data, which is for very legitimate reasons, accessed and analyzed by national security or law enforcement authorities, has been in the first place collected for commercial reasons. And therefore, and that's at the core of any robust and modern privacy regime, when we are considering and we are talking about continuity of protection, we also have to consider the safeguards, the limitation that apply to government access to data. This is at the core of the Schrems II judgment, but this is also something that I'm sorry, Samm will mention it. This is something also that is very much at the core of the US debate. This recognition that data is strategic, is sensitive, and when it has to be accessed under certain protection. Tik Tok, but I'm also thinking about the Clean Network initiative, where the state launched by the State Department in July, and which recognized that yes, certain infrastructure, certain technologies might be exported, might be shared, but this should happen between trusted partners that share certain common values, including privacy. And I think that beyond the many questions, concerns, sometimes anxiety on Schrems II, I know this is very, very much present. There is today, because of that broader recognition of the importance of these issues, there is today more common grounds between like-minded partners. This question of governance access and frame governance access versus unlimited governance access is considered as a distinctive feature that distinguishes a certain regime based on rule of law, democracy, human rights from certain other actors and certain more authoritarian actors. And that's why it's not a coincidence that for the first time we see an organization such as the OECD saying, well, if we are talking about data flows, we should facilitate data flows. We should facilitate data flows between partners that share certain principles and certain values, and that should also include a number of basic principles and safeguards when it comes to governance access. This is not against governance access. It's simply to make sure that governance access takes place within certain parameters. And the fact that the OECD is now trying to develop these common standards is something that we support very much. That we want to actively contribute to, and which is a sign that this is now a part of a much more global conversation, and that's very good. It's on the basis of those standards, that convergence, that we can facilitate safe, trusted, and free data flows.
Thanks a lot, Bruno. So, based on this, I would like to pass the mic to Samm for some comments on the TikTok case in the US. As I see, we could also sort of draw a comparison between what happened in Europe with Facebook and what happened in the US with TikTok.
Sure. So it's interesting that over the summer, the TikTok controversy in the US blew up at the same time as the Schrems II decision came down. But I think what that led to, in a way, is a bit of a false equivalence in terms of looking at US surveillance system and the Chinese surveillance system. And that's an important problem that needs to be untangled. But it's happening in an environment where I think the US is moving towards greater assertions of data sovereignty, because, to your point, Riccardo, of the intertwining between privacy and national security. And I think even going into the Biden administration, we're looking at growing bipartisan consensus that privacy and national security are intertwined and sometimes, and the US is increasingly looking to regulate data through a lens of national security. Here's the challenge that I think the TikTok saga really brought to the fore, which is, first and foremost, the US does not have comprehensive federal privacy. So there are no criteria to evaluate the risks posed by an app like TikTok. And the question is, to what extent are these risks privacy risks? To what extent are these US national security risks? To what extent are these economic competitiveness risks? And I think there's a need to, one, disaggregate those distinct risks, or in cases where they blur, to be specific about that. And then the question is, to address them, does the US need a comprehensive federal privacy law? I would say yes. But then a second question is, how are sort of country agnostic data governance issues, how will those work in relation to criteria specifically related to evaluating the risks of foreign data extraction? And I think that there's probably a need to do both. And the question is, how does the US do this in a smart way? Because overreach can also create a precedent where in Europe, in India, if we began looking at, demanding that foreign companies open up their algorithms and go through all kinds of hurdles based specifically on country of origin, those tools then get turned around to US platforms, right? But I think that there also are specific foreign data extraction risks connected to China. And this gets at the point that right now, as we look around the world, ByteDance, TikTok's parent Chinese company, is in a position where it is collecting data globally in the United States of
I wrote no.
Oh, okay, sorry. The US has a problem right now where the safety net is women. So we have no childcare. So you'll see someone coming in every moment or so. But the point that I was making is, right now, the US and China are the only countries in the world that have global platforms that are collecting data in each other's countries and globally, backed by massive surveillance states. So in this environment, data does become a national security issue. The question is, at what point do those tools then, how are we making ourselves more secure? If we ban TikTok because of country of origin, what is the collateral damage to that? Can Chinese platforms access that data on the open market? This week, a report came out that said that the US Defense Intelligence Agency was buying commercial data sets to access smartphone location data without a warrant. So what is the delta? And I think the Biden administration is in the process of, one, evaluating distinct risks that come with data access by foreign governments, but also what measures can be put in place that can actually close those security gaps. Or I think we're also potentially looking at a US data sovereignty approach, which increasingly will keep American data at the physical border of the US rather than go towards a government like China. And this is the challenge, I think, of this era for us.
That's fascinating, and these scenarios of data localization around the world are really becoming a major policy issue to address. So thanks a lot, Samm, and this is a perfect transition, I would say, to some comments by Mrs. Lekhi on how national security considerations, which role they have played in the discussions within the Joint Parliamentary Committee to define also data localization provisions in India. I'm afraid.
Okay, good evening, everyone. And so localization is not a term which we have discussed. What we have discussed is balancing between the individual liberties and privacy vis-a-vis national security. Now, any democratic country which understands the rule of law principle, due process of law, will also understand that these are genuine concern and there is no one value benefits over the other values. So all the three values need to be balanced, and it is in which situation, which country, which jurisdiction one is dealing with, that all these three and which circumstances three will be considered. We are all very well aware and very rightly pointed out by the speaker before me that China is a big concern. Now, China is a big concern for countries where it is a few thousand kilometers away. In my case, there is just a few kilometers away and just across. And we have seen the aggression happening right at LSE, and the kind of strategical and tactical move this country has imagined. You can think that it is coming from that perspective. Number one. Number two, there have been all kind of intelligence reports, and the intelligence report is that so many different cell phones which are made in a particular country were interceded, and seeding had happened, computers to servers to everything else, and which took other country to detect almost 3 years. Now, whether that has happened in India, not happened, because we've really not tested, and I don't think any other country or any other jurisdiction has even gone to that extent of knowing. So far as algorithms are concerned, I can, from personal experience, say that from the experience of social media like Cambridge Analytica to everything else, these are all unsecure platforms. And whether the data which is being procured through AI methodology, where it is not a question of just knowing the location of various phones, it's also a question of how those locations can be used. I really don't want to dwell into it, but we know the privacy concerns, which are in turn the national security concerns. The funny thing is, before the big tech data collection, the security concerns or spying and such activities were concerned towards or were activated towards certain individuals in certain position of power or relevance in various places. But today, every individual in every country is vulnerable to such activities, and that is the worst. So now one may say that a particular app which is made in one country, data is stored in third country, is downloaded in another country, and that data is used for certain utility but sold to a country which does not respect human rights or does not even recognize democracy. Now obviously it's a challenge for democratic countries, and how do we meet that challenge? So fair AIs is one aspect which has to be dealt with. And if anybody wants to do business with any other country and is beneficiary of ecosystem which is provided by democratic principles, has to show the fairness of algorithms. And until and unless that fairness exists in the system, the bias will constantly exist. And we've seen in various examples, whether it was Egypt, it was Belarus, it is we've had a recent example of CAA. We've seen how social media was used to cause damage to the democratic fabric itself. Under those circumstances, to have some kind of regulation and a due process of law is very, very relevant. And that is not with respect to only social media. Social media is a challenge to democratic process because of opinion building and suppressing certain views or enhancing certain views. It is a very relevant tool. But even when it comes to economy or commerce, etc., we've seen that in normal life, every country has rules, regulations against counterfeit produce and counterfeit products or non-IPR approved products, etc., etc., or copywriting, patents, etc. But through e-commerce platforms, you can sell counterfeit products, and there is nobody looking at how can that be the law? So these are some of the challenges which we as democratic countries, whether it's Europe or US or UK and other regimes, have to deal with it. And somewhere I feel there is a need for more and more global cooperation if we want globalization to sustain, and if we think uh, uh, data is the key, then only regimes which follow the regimen and which follow the rule of law can have access or transfers, but others which do not follow those rules, regulations, and do not learn to abide by the rule and regulation have to be kept out of that process. The advantages cannot accrue to them. So taking advantage of democratic system to enhance non-democratic process is the key element which we need to deal with. And ultimately we all need to understand that if data is the new oil, how can everyone be digging into your personal well? But at the same time, there has to be value system attached to it where you can exchange it, where you can value it, and where benefits can accrue to the people whose data is being utilized for whatever purpose. And when it comes to national security, I am of the firm opinion, and not me alone, but I would say the committee, we've had various judgments by the Supreme Court, and where due process, reasonableness, fair procedure, etc., are the grounds on which national security can be taken care of. Now, national security will have multiplicity of or different layers in which it needs to be used, and those different layers will come into play as the law rolls out, and based on that these principles will have to be adjusted, accommodated, because I am of the firm opinion that democracy gives us the ecosystem which can protect our freedoms and privacy. Now, to protect freedom and privacy, we definitely require democracy. And for democracy to exist or assert itself, we need national security. If national security itself is going to be damaged by autocratic regimes and countries, will freedom exist? Answer is quite obviously no, because those are the very countries which do not, where you can't even debate on data privacy or access to internet or access to other forms of communication. Now, if they are the ones which are damaging the national security framework, there can be no individual freedom and no individual privacy law. So I think it is not A versus B, it is a conglomeration of everything where an act of balancing needs to be done, and protection of individual privacy and freedom is the most important aspect of a democratic life. And for protecting that democracy, I think national security becomes a relevant tool, and that is how we need to look at the law. And I think in the law which will shortly come before the world, you will see a very fine balancing act is what has been done. And I should be thankful to GDPR or the framers of GDPR, because that gave us a foundation and a platform. And being the very first law which worked on data privacy, or which thought of individual rights and freedoms, and to think beyond that was assigned to our committee, because our committee got a foundation and we had to build the building above that, and which we have done. So certain gaps which existed with GDPR, we have tried to rectify that also.
Thank you very much, Mrs. Lekhi. You covered a lot of very interesting points that I hope I will manage to raise later on in the discussion. We're running a little bit behind schedule, but still I would like to hear some thoughts on privacy and national security from Audry Plonk and the work that OECD is doing. It seems that there is there is consensus on the panel that to address some of these concerns, it is important for governments to find common grounds, and so the OECD might really be that discussion forum for these issues. What do you think, Audrey?
Well, thanks, Riccardo, and thanks for having me here today. Well, we certainly hope the OECD will be a forum, at least one of probably multiple forums for that discussion. I think other panelists said it well when they said that privacy and national security are now very much intertwined, and no longer can we really afford, our economies or our national security establishments afford to treat the issues as completely separate and as communities of interest that don't talk to each other and don't understand each other's points of view, legal authorities, policy objectives. And so we are trying, within the context of the OECD and member states, to bring those communities together for the purposes of gaining a greater understanding of both national policies and laws that govern, in this particular case, how governments access data held in the private sector as an ongoing topic that's been difficult in the long-standing discussions around privacy globally, but also transatlantically. And I think the fact that we are initiating this effort comes from a review that we've done of the implementation of the OECD privacy guidelines, which everybody here knows is a fundamental instrument in all privacy laws around the world. And in looking at the implementation of those guidelines, we examined the issues as you've discussed, Riccardo, of data localization, data sovereignty, and this idea of how do governments get access to data, and what are the rules around it. And in going through this process of both doing some research and writing papers and working with our member countries as well as stakeholder groups, we've learned a few, I think, pretty important things. And one is that I think we're at a moment in time where it's important to take a new step in this discussion. And so the Committee on Digital Economy Policy, which is my responsibility at the OECD, decided that this is actually quite an urgent issue following both the Schrems II decision, but also the concerns that countries have that were expressed here by other panelists about different approaches to gathering data, private data about people, approaches that exist in other countries that may not respect rule of law or follow a transparent or due process policies. So with that backdrop, the committee decided, no, this is a step we need to take, and we need to do it fairly urgently and quickly. For a few reasons, I think both because we see now how converging these communities are, but also our economies depend increasingly on data. And while it's difficult to value and measure and put a price tag on data, we know that there's a relationship between data and innovation. We know that there's a relationship between data and productivity and data and entrepreneurship. We also know that many emerging technologies need data to be effective at what they're doing. And so we really have also not only a national security, but an economic imperative to come to the table to try to find some common ground, at least within the set of OECD member countries that are that have a similar values base and are like-minded. So we're at the beginning of this work. We're very excited about it, and we'll be doing many stakeholder consultations. But I think also drawing on the expertise of many of the panelists and the community of people who have long looked at the two sides of this issue and tried to find global solutions to what is an increasingly global, I would say, problem. But the more data we have, the more it flows and needs to flow, but also the more restrictive we sort of tend to want to be for the purposes of either privacy or industrial policy or other or other reasons that countries have. So I hope that gives you a sense of where we're taking the work. I know we're behind time, so I'll stop there and give it back to you, Riccardo.
Thank you, Audrey, but I couldn't have asked for a better transition to the next point I wanted to raise with all of you. So the economic aspects of data sovereignty, and I see that governments around the world are considering the creation of local data set for high value data. And they are also considering to mandate data sharing requirements and so on. So access and data sharing can become a competitive advantage for countries around the world. So my question to all panelists now, and probably, I don't know, we can start with Mrs. Lekhi, and maybe followed by Audry and Bruno and Samm. How do you see this? Is it really a competitive advantage? So we see India, for instance, that is developing a non-personal data bill, and there are provisions on data trust. There are provisions on mandatory data sharing. The European Commission is developing its own data strategy with a number of legislative initiatives, like the creation of data spaces, European data spaces. And also China is in the middle of a new legislation that would be the first privacy framework. So how the panelists see this? Maybe we can start with Mrs. Lekhi, if she agrees. A few minutes on this point. Thanks.
So the first thing is that whether it's GDPR or it's other regimes, what are we trying to achieve? And since we have to act in a balanced way, we do need data. E-governance is something which has benefited Government of India. And reaching out to 130 crore people and maintaining transparency, giving subsidies, reaching out to digital inclusion, helping people with access to governance modules, etc. So digitization has gone a long way. And when it comes to sovereign powers, the whether it's freedom or it's other fundamental rights, who do we hold responsible for? Now, I obviously can't hold responsible a private company whose CEO is sitting in some other country, and the CTO is still in another country, and the only model and module they expect is to increase their share value, and nothing beyond that matters to them. Cannot be the custodians of my liberty and cannot be custodian of granting access to governance. Now, granting access to governance is definitely is the responsibility of the government. Now, for achieving that, government has to know what all is being collected, whether the collection has been purposeful collection or it has been exceeding the purposeful collection of data or processing of data for that matter. My right as an individual to enforce my fundamental right, right to protect me, is the right of the government, and I can haul the government before the court, which is another pillar of governance, but independent of the government in our system. And I can take the government to the court. I can't take the CEO of a private company sitting somewhere before the court, and even if I take the CEO, it will be a futile exercise in real term. So law has to provide for in what mechanisms business can be done or cannot be done, and somebody has to abide by the legal principles of the country in which they are benefiting out or getting advantage of. So far as access to data by the government is concerned, that access to data by the government is for various purposes. Now, whether it is non-personal data or personal data, because custodian, and as lawyers on the panel and otherwise will understand, every sovereign government, there are certain acts which are sovereign acts. So protecting my rights is an act of sovereignty. Uh, Working out a contract which is a valid contract. Not I cannot enter into a contract with someone and enter into a pact of suicide, whether out of ignorance or out of greed or out of some kind of assurance. I cannot enter into a contract which will which leads to suicide or my own murder or somebody else's murder. These are unethical things, and thus they are invalid or void contracts, void ab initio. Now, who will govern that? Obviously, these contracts will be governed by rule of law, and whose duty it is? It is the duty of the government. And how will government act out its governance principle? Only after accessing the fair policy or fairness of its own system, and thus access to the government has to be mandatory, because my right is against my government. And since my right is against my government, and also it is me asking the government to comply with their constitutional methodology to protect my right. So under those circumstances, these are falling within the purview of the principles of sovereignty, and thus access to data and detail in circumstances will have to be given to the government of the day. That's how I look at it. And that access, I'm not sure how non-personal data policy will be brought out, but one thing is very clear. What is non-personal data? It is basically anonymized personal data. And if anyone else has the key, every non-personal data becomes a personal data. Thus, the action, whether it's personal or non-personal, will have to lie with the authority, and the law has to apply. And if I see the GDPR is also about general data protection law. All other laws are data protection laws. So when you are dealing specifically to protect the personal data, you necessarily have to deal with simultaneously with non-personal data, and thus they are also integrated, and one leads to the other, and any right and sensible person can detect one from the other.
Yeah, thanks. It is indeed very interesting, the relationship now between personal data and non-personal data, and both have a major role to play in data governance strategies, of national data governance strategies around the world. I wanted to follow up with Audrey what she was saying earlier about the economic dimension. And so what is the value of localization? What is the value of data flows? Can we answer to these questions?
If we could answer that question, we would probably not be on this panel today, but we're trying really hard to get better at how we understand data value. Let me say a few things that we do know. We do know that it takes a long time for our models to gather data about data so that we're looking at current trends. So we can talk, so some of the data I'm going to give you now is dating back to about 2018, some of it 2019. So as you can see, there's a lag, and in our current environment of 2021, we sort of look at data from 2016, 2018, and think of it as old. But we do know, based on official data from countries that the OECD has, that firms across OECD countries are increasing their use of data. It still varies significantly across sectors. So in some sectors, particularly finance and transport, there's high use of data. We've also seen a significant increase of data use in the manufacturing sector. For example, more than 25% of all ICT firms in the EU used big data. Were using big data in their production in 2018. Whereas it was only about 10% of all firms on average. So we know that data is important, and it's being used, but it's not oil. And I will go back to my colleague's first analogy of data being oil. It's not oil, and we tend not to use that analogy because it's actually non-competitive. It's a resource, it's an input as a factor of production, and it can be used and reused many, many times, and it's not finite. And so that makes valuing data extremely difficult, and it puts it in a different economic realm than a natural resource like oil, where it's a bit easier to know what's going to happen. And so that concept and that challenge has plagued economists, and I think privacy professionals and policymakers for quite a long time, because it's difficult for us to make even a correlative relationship between a policy approach to data, open, closed, just to put a label on it, and the economic output or the economic effect of that data. But we continue to try. I won't bother you with all the details of the work we have ongoing about how to measure data and data flows. But just to tie it back to the last point from the previous speaker about sovereignty, I think one big concern that we've uncovered in our work on the privacy guidelines is, how much we want to think about this as sovereignty. There are exemptions for sovereignty in the OECD privacy guidelines. We did some recent work on data localization specifically, where we raised some questions that I think are worth repeating here for the experts on the panel and tuning in to say, do we really want this to think about this as data sovereignty or technology sovereignty, and how does that relationship of thinking about data in a sovereign or non-sovereign context relate to existing law around national sovereignty? Because in most cases we have exemptions, including in the OECD privacy guidelines, for sovereignty. States have exemptions for that. So it's something to think about when we talk about what we're trying to get out of data and how we're trying to protect people.
Thanks, Audrey. Thank you very much. Probably I would like to hear from Bruno first and Samm afterwards about this point of the economic dimension of global data flows and the data localization in case.
Yes, well, a couple of things on that. First, I think there's a lot of misunderstanding about what sovereignty means and data sovereignty means. Sovereignty is often indeed translated as protectionism or localization. For us, in an interconnected digital world, a borderless world, where moving data is a matter of one click or two, sovereignty means three things. It means certainly being more assertive, and that's translated in what we do by, for instance, investing more in digital tools, digital infrastructure, because of the importance of such tools and infrastructure as we invest in energy equipment or other strategic areas. And you will have seen that in the last big budget package of the EU plans to invest 2 billion to foster the development of data processing infrastructure tool and other related architecture and measures. So that's one aspect of sovereignty. The other aspect is ensuring a level playing field at home, that everybody that offers goods and services on the European market is subject to the same rules, regardless of where that company is established in the EU or outside the EU. And that's the approach we have, for instance, followed with the GDPR. A third aspect of what, between inverted commas, sovereignty can mean on our world is contributing to the development of international standards, to the shaping of these international standards. In a borderless sector as data processing, you of course need international standards, and you want that those standards reflect your values, your key principles. And that's why I think this work, which is taking place at the international level, for instance, in the context of the OECD, is so important. And by the way, it's interesting to see that work has not been triggered particularly by the EU or even by the US. It has been triggered by Japan through an initiative which is called Data Free Flow with Trust, and I think it says it all. We want, with like-minded partners such as Japan, such as the US and others, to promote free flow of data. We all need data flows. The economy needs data flows. Cooperation between public authorities need data flows. Social interactions need data flows. Continuity of government operation, business operation during the pandemic need data flows. So this is not about building walls or erect other type of barriers. It's about building on and promoting a model where data flows can take place on the basis of solid safeguards. And that's what we do in the EU. That's what we have done indeed with Japan by creating, through our mutual adequacy arrangement, the biggest area of safe and free data flows in the world. That's what we will work intensively with the US in developing a successor arrangement successor arrangement to the Privacy Shield. And that's what we are doing with many other partners. We are concluding in these days adequacy negotiation talks with Korea, for instance. I think time has also come to go beyond that simply bilateral approach and to create, through a sort of network effect, connect all these arrangements and indeed work on international standards. And that's also what, because Riccardo, you mentioned our initiative on European data governance. European data governance is not about localization. It's about facilitating data sharing across the EU between different sectors. And that requires a trust. And therefore, it's about increasing trust in sharing data, because sharing of data between the public and the private sector, between individuals and the public and the private sector is so essential. Think, for instance, at the medical, at the research, at medical research. And this is done, of course, in full commitments with our international obligation in the area of trade and of free trade. But to create that trust, you need, of course, compliance and adherence to a number of principles that concern not only privacy, but also protection of business secret, of IP rights, etc. That's what our European data governance is about. And then maybe lastly, as a very recent expression of this policy, which I've just tried to bring the affirmation and an assertive approach to certain key values and principles and openness to data flows. Let me mention the agreement we just concluded with the UK, the famous Trade and Cooperation Agreement, which has in its digital service chapter a couple of very interesting provisions that I think address many of the issues we have been discussing. A provision that for the first time in the history of trade agreements prohibits a number of restrictive data or digital protectionist measures, including localization measures. And on the other hand, reaffirms the regulatory authority of the party in regulating privacy, provided that those parties have mechanism for transfer, that their privacy legislation provides for mechanism for transfer. I think it's a very interesting attempt, and I think a successful attempt to draw a delineation between data protection, genuine data protection on the one hand, and data protectionism or digital protectionism on the other hand.
Thank you very much, Bruno. This was a very insightful overview of topics, and you are introducing also trade, which I saw also in the audience. It's something that was raised as an important point to make during this discussion. I would like to conclude this economic aspect, and I like this reference to trade that Bruno made, to talk with Samm if she's available for concluding this round, this trip around the world we made, trying to explore the economic dimension, and so the competitive advantage also of some countries compared to others.
I'm so sorry. I was talking to my son when you asked the question. Can you?
We're still discussing the economic dimension of data flows. Hence, I wanted to have your perspective, especially because Bruno mentioned trade issues, and last year there were very strong tensions between U.S. and China. So since you are involved in that type of work, I wanted to hear more from you on this.
So I think one thing that would be helpful to do is to understand how the economic dimension actually plays into the build out of China's own data protection regime, which is rapidly taking shape. Because I think sometimes, again, as in the US, I said the US is increasingly looking at data through a national security rather than a trade lens. And I think there's a tendency to do the same with the way that we look at the developments going on in China's system. Within China's system, there's a tension between three factors. The way that the government is also increasingly looking at data as an economic resource. They've called data a new asset of strategic production and are setting up data exchanges for firms to come together and trade data. There's also the question of state access to data. From private companies, which is the way that I went with the trade conflict between the US and China. I think that's the central issue that US policymakers are focused on, lack of constraints there. And of course, Europe has similar concerns. And then the third tension I think that we're seeing in China is from the public increasing demands around their own personal privacy and looking for protections against rampant abuse online of people's information. So when we look at the emergence, I think, of China's system, we have to keep those three factors in mind. Most recently, there are two draft laws, a personal information protection law, a data security law, which would become the most authoritative legal documents to date, spelling out China's data protection, building on the concepts of the cybersecurity law. And I want to just briefly mention each of those three factors in turn. So on the big, I think this is sort of the most important one from a trade perspective with Europe and the US, is this question about government access to data. Surprisingly, the personal information protection law specifically describes constraints on what are identified as state organs in terms of their access to data, saying that they're subject to limiting principles of legality, legitimacy, and the like. Now, of course, cynics in Europe and in the United States and elsewhere will go, well, this isn't meaningful at all. Why would the government put any real constraints on its ability to access that data? And to be sure, there are real enforcement challenges. The fact that none of this is spelled out in real detail, and there are massive national security loopholes to that language. But it reinforces the fact that I think that there are debates within the Chinese system over these issues, and part of that debate is actually driven by one, as I said, the public backlash. We've seen we've seen a number of lawsuits related to automated decision making and the use of facial recognition and surveillance technology in public spaces. So there is growing demand from the public there and the Chinese Communist Party actually recently cited personal information infringement as an issue that will have grave impact on social stability. So they know they have to keep up a certain level of accountability there to the public. At the same time, the laws could be read as essentially codifying or sort of reinforcing the existing authority of state organs to access that data. But there's also an economic dimension, right? And I think that part of these laws, the draft data security law specifically has a provision on balancing economic development with security. It's the second part of the law. And in doing so, Chinese scholars who are writing about these legal developments have said the government wants to be able to carve out kinds of data that can be traded because they recognize this as a factor, to your point earlier, that will drive production, innovation, entrepreneurship at a time when the economy, the digital economy is a significant engine of growth in the shift away from export-led heavy manufacturing. So we're beginning to see these pilot zones crop up around the country in different provinces where companies who are registered can come into the pilot and participate in a kind of data exchange or data trade where certain kinds of data are carved out as non-sensitive, as anonymized. It's still very early stage and theoretical. But I think as far as thinking about China's competitive advantage here, it's really important to look at the way that the government is moving ahead as far as trying to think about how do we regulate data so that firms can tap into its value from an economic utility perspective. And these three dimensions are increasingly going to shape China's own data protection regime as we move forward. Now, United States, I think, is probably primarily focused on the national aspect, so that will dominate trade conversation, as I mentioned earlier. And the question is, to what extent will Chinese companies at all be able to handle American citizen data? Will certain kinds of data be carved out as less sensitive, or is everything going to be grouped into this national security bucket?
Thank you. Very interesting. Thanks a lot, Samm. We don't have much time, but I still would like to make a point regarding the impact of data sovereignty on technology and hear from our distinguished panelists about it. So I see a couple of challenges here linked to the restrictions of data flows. On the one hand, the decreased quality and accuracy of autonomous determinations, because AI systems, for instance, would rely only on local data. And I see also a problem in terms of decreased performance, because technologies like artificial intelligence or autonomous driving may not be able to rely on the global digital infrastructure. I see also an opportunity, though, brought by technology, because there are technologies like federated learning that might decrease actually the need to transfer sensitive data outside the borders of a country. So there are several elements here, challenges, opportunities that might have an impact on innovation. I would like to hear from the panelists, and this is the final round of questions from my side before we open it up to the Q&A. And so I would ask maybe a couple of minutes each, starting from Audrey, Bruno, Samm, and Mrs. Lekhi to conclude. Okay, so Bruno, would you like to?
Sorry, but I had also a correction problem. What is the question?
Okay, so my question was about innovation and about the risks of restrictions of data flows, and at the same time how technology can help in some cases to reduce the number of the amount of data that needs to be transferred. And I was referring specifically to federated learning in the context of AI. I just wanted to know if your institutions and government around the world are looking at these challenges and opportunities for innovation, and a comment on this.
No, but we understand, and the initiative I referred to, such as the data governance and others, and also support to data free flow with trust, is a recognition that innovation, economic growth needs data sharing, needs data to move, needs data to be aggregated for questions of quality, for questions of innovation. So this is precisely why we are promoting those forms of sharing and those forms of transfers across sectors, across industry, between the public and the private sector, between also initiatives around individuals accepting to share their data. The problem of the question here is how we make that sharing and those data flows safe, trusted. It's certainly this is certainly not an indication of any how can I say negative approach to transfers or sharing of data. As to then a number of principles, indeed, there are a number of principles, by the way, are often comes from our data protection legislation, that are enshrined in our data protection legislation, that are very relevant. The principle of minimization, some rules around data security, some principles also that allow individuals to make some decision in a more informed way. The fact that, for instance, in the governance of artificial intelligence, transparency, explainability, challengeability are recognized now as key principles. That's certainly something we support, and that to a large extent comes from our the fabrics, I would say, of our privacy legislation, privacy system. I don't know if that answers your question, but I really had problems even following it when you repeated it, and I'm sorry for that.
Thank you, Bruno. It was spot on, and I would like to quickly ask if other panelists want to make a comment on innovation and the risks related to restrictions of data flows.
I would say that innovation requires data sharing, but data sharing has to be under certain rules and regulations, and with whom we are sharing. Now, most interesting theory, which my friend just talked about, how China is coming up with its own law, a country which has not allowed any of the big techs in its own country, but has backrolled, entered into the economy by controlling those companies, by funding, financing, and investing in those companies, is talking about a data regime, a most non-transparent regime when it comes to the value system, but understands today that everybody has become aware of these stealth actions which have taken place in the past, is today trying to come out and say we follow some kind of law and norm without allowing anybody else to get any access to. Now, today they understand that until and unless they come up with a law, every other country will stop sending their data for processing and also for manufacture. We know the value of data, whether it is MSMEs or knowledge sharing or data sharing can bring, especially in the field of AI, robotics, so on and so forth. The moot point being, there are people who are producing data, and that data can be leveraged for economic purposes. What will be the benefit accrued to the people who are producing that data? And in the first instance, that generation of data or that data principle or that action needs to be compensated in one form or the other. And if there is no compensation and only one or two countries start sharing all the data, start controlling it, if there was no value attached to it, why should those details be collected in the first place? The fact is, the data is collected, stored, and processed because there is an economic value attached to it. And economy of scale and economy which is transparent and services which are more global in nature, because they are impacting lives in one form or the other, have to be under fair regimes and fair form of law which is created, which creates due process of law and also sets the standards. And those setting of the standards is what the laws are all about. Not the autocratic regimes which have not allowed their own billionaires to come out and criticize some inane comment being made, and the person disappears for 3 months. And that country today is talking about legal ramification. Are we all, I mean, I don't know, I don't want to use a bad word, but we are not high on drugs. I think we all understand how the regimes function. And under those circumstances, every intelligent being has to look at the aspects of data sharing to economy, to the networks in a more practical way. And those practical practices will become the international law and regime.
Yeah. Thank you, Mrs. Lekhi. Since Audrey is back, I wanted to take the opportunity to ask something about technology innovation, but the OECD has been looking at vertical sectors like the healthcare sector as a very promising area also for deploying new technologies that would address privacy issues, but also improve innovation.
Yeah, thanks. I mean, I think you hit the nail on the head with the question, Riccardo, which is, you know, on the one hand, we need to be looking for mechanisms whereby we don't always have to transfer data to have a positive effect or output. And so, you know, for example, there's ongoing discussions about how to enable travel around Europe and more globally and during the pandemic, and how would we transfer personal health data between countries? And so the question is, like, do you actually really have to transfer it? Can't you just either you know, make a hash of it, encrypt it, have the individual show it at the border? And so there's lots of discussions there. And I think people are really cluing into the fact that, like, we have to design and architect systems whereby we don't have to always have a data transfer, both for privacy reasons, but also for security reasons, and also for just bandwidth and necessity and practical infrastructure reasons. So just a couple of notes of other work. I mean, in 2015, the OECD put out what I think is an important paper on data-driven innovation, where we make the link between the use of big data and innovative firms. And that work continues, and we continue to try to measure the role that access to data and has in driving innovation. And as many people have said, it's difficult to put a particular value, because what's valuable to one firm is not going to be valuable to another firm. This kind of data, you know, may be valuable when put with a different type of data, but if it's not correlated with other data, it's less valuable. So it's difficult to put, you know, you can't really cut data into different categories and stick price tags on it. But we're looking at other novel ways to try to measure how firms create value out of data and turn that into innovation. The other thing I would say is we're looking at data portability as was an output of the GDPR, but looking at the role of data portability in both the economics of how firms use data, but also in, you know, issues of competition and work with our competition directorate. So I'll leave it at that, and apologies for the lengthy intervention.
Thanks a lot, Audrey. We have some questions, and I would like to ask Mrs. Lekhi, if possible, in a minute, to answer what are the gaps in the GDPR that the India Data Protection Bill is trying to address.
Since the report has not come out, I can't speak a lot about it. But there are gaps, and the gaps you will read about it. Just wait a little bit. My difficulty is I cannot say anything till the report is put on the floor of the Parliament. So I'm bound by my oath of secrecy.
Okay. Thank you. We look forward to read the final version in the coming weeks. So we're about to close. I want to thank everyone, but I have 3 takeaways, and so probably maybe 20 seconds each if you want to make a comment. We need balanced solutions to privacy and national security as the only solution to address global data flows. I noted also that the economic value of sovereignty initiatives needs to be assessed, and also I see that there is consensus on technology. So and then the importance of driving innovation through data. So with this, I would like to thank all my panelists. Thanks a lot for joining today and for coping with all the technical issues of this panel, but it was fantastic, and I'm very, very grateful for all your insights on this topic. Thank you very much.
Thank you.